One attorney says, Your Honor, I offer this Exhibit A into evidence. Another lawyer at another time turns around and says, Your Honor, I offer this Exhibit number 1 into evidence. What's the difference between using an alphabetical designation compared to a numerical designation when talking about different exhibits? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now we're talking about exhibits, trial exhibits. Now, when we go ahead and try and get something into evidence, first we have to identify what it is. Why? We do that because when the court reporter is recording all the information that goes on in the courtroom, she doesn't know if we say, hey, Judge, I want to introduce this. Nobody knows what that is except the people in the courtroom. But for the purposes of the transcript, and now later on, if the case gets appealed, the appellate court, what do they use? What do they rely on to see what went on at trial? The transcript. And if now all they're reading is, Your Honor, I offer this into evidence, the appellate court, the judges who are now reviewing this, have no idea what this refers to. So now we have to identify whatever exhibit it is. It's a photograph, Your Honor. What's it a photograph of? It's a photograph of the accident scene. It's a photograph of my injured client. It's a photograph of the injuries. Okay, let's mark it. What does that mean? Now we have to actually put something on here so that everybody in the courtroom, every single person, knows what this thing is. We have a list, we have a chart of identifying exactly what exhibits are being used at trial. This way it helps everybody understand, the court, the judge, the attorneys, the jury, understand exactly what it is we are talking about, and the witnesses. Hey, Dr. Jones, I want you to take a look at exhibit number 7. Do you see that? That's a copy of the patient's medical record that is now in evidence. You see that? Yes. Okay, turn please to page 27. Everybody is on the same page. Everybody understands and knows what this thing is. So if I intend on introducing this booklet, this book, into evidence, I say, Your Honor, I'd like to mark this for identification. Terrific. Let's mark it for identification. Since I represent the injured patient, known as the plaintiff is the one who gets numbers for every exhibit we try and introduce. So exhibit number 1, exhibit number 5, exhibit 12. We use numbers to identify things that we are trying to show, whether it's to show to the jury, whether it's something we want to get admitted into evidence. We use numbers. When the defense lawyer tries to get something into evidence or tries to have something marked as an exhibit, what does the court use? They use letters, A through Z, and then double A, double B, double C, whatever it is, okay? But they will use letters to designate the exhibits that they are bringing in to now show to the jury. So there's never any confusion about who brought what in, about whose evidence this is, whose exhibit is this. So now, hey, Dr. Jones, I'd like you to look at exhibit number 6. Exhibit number 6 we see is the patient's medical record from Dr. Jones. Do you see that? Yes. All right, can you turn please to the patient history? Yes, I see that. Okay, so we now all know exactly what it is that we're talking about. All right, Dr. Gold, you've brought with you an anatomical model of the lungs. Let's mark this as an exhibit, plaintiff's exhibit number 2. There may be instances where I want to introduce this into evidence. Before I can actually get this into evidence and have the jury be able to see it and read it and look at it, we first have to have it marked as an exhibit. All right, counselors, let's mark this as exhibit number 2. Terrific. Now I'm talking to the doctor about this particular exhibit. Now, doctor, explain to us what this exhibit is. Tell us, what did you learn from this exhibit? What information did you glean? And now I'm going to spend a great deal of time explaining to the jury what this exhibit is and why it's important for this particular case. And after I've established and laid what we call the foundation, the elements needed in order to get this into evidence, now I say, Your Honor, at this time I offer this document into evidence. Now the judge turns to the defense lawyer and says, any objection? Well, if I've done a proper job, the defense attorney should have no objection. But even if he does have an objection, in all likelihood, as long as I've done a proper job laying the foundation for everything I need to get this document into evidence, the judge should overrule the objection. So now the court reporter will go ahead and mark this as exhibit number 2 in evidence. That's a different designation than simply marking it for identification. Either way, all the attorneys and the court has to keep track of all the different exhibits, because by the end of a trial, there are many, many exhibits that are used by both sides. So we have to know who introduced which exhibits, and you should also know, at the very end of the trial, when the jury goes out to deliberate to decide whether you're entitled to a verdict in your favor, The jury is permitted to ask the court for all of the exhibits that were introduced and admitted into evidence. Those exhibits that were simply marked for identification cannot go back to the jury. They cannot go back to the jury room, and the jury will not be able to see them and review them once they are in there deliberating. But any plaintiff's exhibits, any defense exhibits that were marked into evidence, now the jury can get, they can review, they can talk about it, they can see it to their heart's content. So why do I share this great information with you? I share it with you because if you're a litigant, you're going to see this as you go through your trial. If you are an observer and walk into a courtroom in a civil lawsuit involving accident matters, medical malpractice matters, and even wrongful death matters, you're going to see this as well. And by the way, if you walk into a criminal court here in New York, and now you watch a trial, you're going to see this also as well. But instead of plaintiff's exhibits, you're going to hear about the people's exhibits. Those are the exhibits brought on by the district attorney, and then also defense exhibits. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these types of cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking about doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.